Hi, I'm Tran. I'm here to talk to you about a new ruling from the Fifth Circuit Court of Appeal. It basically holds that an employer cannot enforce arbitration against employees who have sued a customer of the employer. The case is called Kenneth Newman versus Plains All American Pipeline, and the opinion just came down on April 14, 2022. Now, this case was originally filed in 2019. Here's a copy of the complaint. As you can see, the Kenneth Newman filed a collective action under the Fair Labor Standards Act, and he had sued a company called Plains All American Pipeline. Now, he did not sue his employer, he sued the customer of the employer. And the class action basically says that the inspection company, Plains All American Pipeline, had hired all these inspectors to inspect their pipelines, and they did not pay them overtime for all hours worked over 40, and they had misclassified them and paid them a day rate. That's the case and the allegation. It was filed in Midland, Texas, and so the employer, who was not sued in this lawsuit, intervened. And so you can see the name of the employer here, Cypress Environmental Management. They are the intervener appellant in this case. So the Midland District Judge that oversaw this case allowed the employer of Kenneth Newman to intervene in the case. And after they intervened, Plains All American Pipeline tried to enforce an arbitration agreement between Newman and his employer, Cypress Environmental Management. The judge rejected that motion to enforce arbitration. They made several arguments, including who should hear the arbitrability of the arbitration agreement, the venue and scope of the arbitration. But the district judge wisely held that the first threshold issue is whether or not there is an agreement between the parties, Mr. Newman and Plains. So the judge ruled against Plains, the defendant in this case, and Plains appealed to the Fifth Circuit Court of Appeal. So the judge that issued these rules that sat on this panel was Stewart, Clemeth, and Ho. They held that they first addressed the issue, the threshold issue of whether or not Plains has standing to enforce this arbitration. Okay. First, they rejected Plains' argument that the plaintiffs agreed to arbitrate the question of enforceability. They did not. The court held that this is an issue for the court because we don't know, the court basically said, whether or not Plains was even a party to this case. So, one argument that Plains has made, and many employers in this situation would make, is that the customer, the third party beneficiary, it's a legal concept in Texas on whether or not the parties agreed that the third party would be a beneficiary of this case. And in this lawsuit, there was some evidence provided on whether or not there was some intentionality between the parties to extend the benefits, the arbitration agreement, to the third party, which is Plains. And what occurred was that the court and the district court and the appellate court looked at this case and the evidence, and they felt that the reference in the evidence does not spell out that Plains could take legal action against the employee or Cypress if they breach the arbitration agreement. It's not clear. Number two, the court held that the employment agreement itself did not clearly state and fully spell out that Plains could take legal action if the employee decided to breach the term of the arbitration agreement. And because of that missing element, Plains did not enjoy what in Texas we call a third party beneficiary. So Texas has this really unique concept, and that is a third party under Texas state law is not a party to the contract. The burden is against them, and they have to prove that they were part of the contemplated beneficiary of that contract. And so Plains was not able to prove that in this case. And so they did not have standing. Because they did not have standing, they're not a party to the case, the court then rejected that, whether their argument that the plaintiff will require to arbitrate the arbitrability of the arbitration agreement. So what this concept means is that usually in an arbitration agreement, whether or not the plaintiff or the scope of the controversy should be subjected to an arbitrator who would then decide if he or she has jurisdiction over the case. You usually know what they're going to say after that. So the Fifth Circuit Court of Appeals said that, well, that threshold issue, plaintiff was not even a party to the case, so therefore they can't even make an arbitrator rule on whether or not this controversy covers them. In addition to that, they said that Cyprus was not an aggrieved party. So an aggrieved party is someone that, because of the breach, has been harmed. And in this case, Cyprus was not sued. Since they were not sued by their own employee, they were not harmed in any way. They have no standing to intervene, and they basically can't do anything because they're not involved in this case by all these employees that Cyprus had hired. But since the court takes a very narrow scope and view of this case, and that is this lawsuit is a Fair Labor Standards Act violation against Plains. And since Cyprus is not a party to the lawsuit, they really can't make any argument about it. Because of all these previous positions that the court has taken, the Fifth Circuit rejected and declined to apply the delegation clause, the form selection clause, and the scope provision. The delegation clause means the arbitrator, not the judge, decides arbitrability. Form selection means it should be arbitrated, the lawsuit should take place in this state, not the other state. And the scope is whether or not the arbitration covers overtime violation. In the end, when a court decides whether or not an arbitration agreement exists, it's necessarily can decide the enforceability of the agreement between the parties. In short, it's the Fifth Circuit is saying if they make a ruling or the district judge makes a ruling on whether or not there is an arbitration agreement at all between the parties, then of course the second order effect is they've effectively made a ruling also on whether or not the arbitration agreement is enforceable. The takeaway for this is that when you are facing a lawsuit filed by employees of a contractor for overtime violation, you have to take a look at the agreement between the contractor and their employees. When employees are faced with a situation, I think it'll be smart if they target the right defendant. If there's an arbitration agreement between the employee and the employer, they can also bypass the employer and just sue the customer of the employer. Why? Because unless the contract was written very well and the agreement clearly shows that when they hired these workers, they intended the arbitration agreement to apply to their customers.